Hello there, and welcome back to International Fathers. I am your host and your creator, Nelson L. Moody Sr. We're still talking about child custody in the judicial system. We went through a whole lot of steps. Our last step that we saw was cross-examination. Our next step that we're going to talk about is the first appeal, because sometimes a court case may not go exactly the way you planned it or you orchestrated it. Therefore, an appeal may be needed. I'm going to walk you through the steps of the first appeal, and we're going to cover the basis of why and what you're going to put in your first appeal. This is appeal from the circuit court in your city to the appellate court of your state. This is how the paperwork will look. Could look. In the Court of Special Appeals of Maryland, 1414 Tigerland Parkway, Triangle, Maryland, 7777. Case number 111-222-D-333. Mike L. Cucumber Sr., 123 Neptune Circle. He is the plaintiff. He is the person, the father, who brought the case to court. Versus Denise Asparagus. She lives at 321 Saturn Place. Circle, Maryland, 00007. He's the defendant. And Paul E. Cabbage at 4211 Mars Solar Suite 14, Circle, Maryland. And he's the defendant. This is what your paperwork could look like on your brief. In the Court of Special Appeals, June term, 2007, number 475, Mike L. Cucumber Sr., the appellate, the plaintiff, versus Denise S. Asparagus, the appellate, the defendant. Appeal from the Circuit Court for Dot, Maryland. And here you have John R. Pineapple. He's the master, the appellant's brief. This is how your paperwork will actually look. This is the front cover of your brief. Mike L. Cucumber Sr., 123 Neptune Circle. As you see, he's pro se. Paul E. Cabbage, 4211 Mars Solar Street. And he's an attorney for the appellate. And these are the things that will be involved in your brief. The table of citations, statement of the case, question presented, statement of facts, and your argument. What I've learned in my court case, of my first two books, When a Judge Can't Judge, My Nightmare of the Court System in Baltimore, Maryland, and When a Judge Can't Judge, Part 2, The Conclusion, what I've learned, the attorneys who went before me, who tried their best to go against me, could not write a written argument. I've read and seen written arguments can be critical in a court case. And since we're talking about Master Pineapple, we're going to talk about some questions that are presented. And one is, why would Judge John R. Pineapple deviate from the first analyzed conclusion to serve what is in the best interest of the children, to be in the father's custody, after hearing two expert witnesses testify on Mr. Cucumber's behalf? Now, expert witnesses, remember in our child custody terminology, part 1 and part 2, we went over what expert witnesses were. Doctors, police officers, social workers, police officers. Those people are expert witnesses. Mr. Cucumber had two of them to testify on his behalf. Number 2, why was Miss Asparagus allowed to contradict herself and denying signing the affidavit? Why was she allowed to do that? She contradicted herself. She lied. That's the bottom line. She perjured herself. She didn't tell the truth about an affidavit that she signed already. Number 3, why would the defendant's attorney, Mr. Cabbage, go along with Miss Asparagus' actions even after she signed the affidavit was shown to all parties, including Judge Pineapple? This is what I say about those attorneys out there that are cunning, sly, slick, manipulating, deceitful, and liars amongst themselves who perjure themselves in court. But unless you have a judge who uses the common sense along with the book sense, he or she will not catch the lies, or he or she will go along with the lies, thus creating a lot of turmoil in the court system, and the child or children suffers. So you judges out there, listen to this. You attorneys out there, listen to this. Don't lie to the judge. For all you students around the world that are pursuing a career in law, always make sure your client is telling the truth, producing facts, proof, evidence, because it can reflect on you, and then the child or children will suffer based upon one lie that you told to the judge. Conclusion: constitutional provisions, ordinance, rules, and regulations. Now, in the table of contents, this part of the brief will have similar court cases in relation to your own court case to show a judge you have cases to support your case. This is plain, simple, and common sense. If your case is built around a child custody issue involving the best interests of your child or children will be with you because your child was allowed to throw things all around the house and to break glass up all around the house. You search court cases that have similar incidents like that and compile them all in relationship to your court case. That will be your table of contents. Like I said, plain, simple, and easy. I designed this book, A Father's Self-Representation, Hosea 4 and 6, Eliminating the Middleman, the Attorney. When I wrote this book in mind that a 10 to a 12-year-old child can understand it. A 10 to 12-year-old child can understand it. Remember that. The statement of the case. This part of the brief will have the initial reasons for filing a brief and record extract. This part will also have your witnesses and some information about them and or what they have said in court under oath. This is the opposite of a case that went smooth, because perjury and contradictory statements now becomes a factor. Whatever the witnesses have said previously, all that information is documented. This is where you can put all that information at in this part of your brief, the statement of the case. The question presented. This is self-explanatory. This part of the brief will have the question or questions as it relates to your case as to why you filed an appeal. And most times you may have filed an appeal because you felt that the judge didn't render you a rightful decision, or something that you had a problem with that the judge said. It could be a number of reasons, but whatever your reasons are for filing the appeal, this is where it goes in the question presented. The statement of facts. This part of the brief gives a summary of events and or a short version of what happened from the beginning to the ending, using facts, proof, evidence, and pertinent information where the information would go. Example: on the above date, the plaintiff / appellate, being represented by himself, stated his case. While testimony was being taken, Mr. Cucumber presented an affidavit signed by Miss Asparagus, telling all the other witnesses information, throwing a doctor's testimony, which is an expert witness, along with medical records. You can add those also. A teacher's testimony along with educational records. Very important. He or she is an expert witness also. Report cards, progress reports. You can also add job and home stability and the ability and the responsibility to handle all the matters that surround your child or children. Remember, Mr. Cucumber told the judge that he's the owner of his own electrical construction company. The attorney for Miss Asparagus didn't understand that from the beginning when he asked Mr. Cucumber, how would you get your youngest daughter to and from daycare? When the judge looked frustrated at the attorney, saying that Mr. Cucumber stated that in his opening arguments that he is the owner of his own company. If you're the owner, you can make your own schedule to accommodate your child or children. And in this situation, in the court system, Mr. Cucumber was allowed to do that because he's the owner of his own company. As I said before, you have attorneys out there who are deceitful, sly, cunning, manipulative, and just straight up liars. Watch out for those. Any and all other agencies may also be introduced in this part, i.e. pictures and documents from the Department of Social Services, Child Protective Services, and the Police Department. All these agencies should cross the same computer systems when a child is or are abused. Therefore, if all that is done, there will be no doubt in anyone's mind whether all these facts are running straight down the same line. But this information that I just read is what would be in the statement of facts. This is just an example. Your argument comes up next. You may want to write in your argument for your case in this section as it relates to your case. As I said before in the beginning, some attorneys in family law don't know how to write a written argument. I've read it and I've seen it. Written arguments are crucial in a court case. Number 1 under argument. Introduction to the case. Explain why you are appealing the lowest court decision and/or conclusion. Bring and introduce those cases similar to yours. As I said before, in the statement of case, you want to have cases that are identical to yours. That the judge can look and see and compare. Ruling on false allegations. This is still your argument. Your Honor, you ruled on false allegations. That's not true. Where is your proof? State the facts as to what happened wrong in your opinion. Your Honor, I think that this was wrong. There was no reason for this ruling to go this way. The opposing side didn't have facts, proof, or evidence, or witnesses, or any pertinent information that will allow you to render a decision that you have made. It's my argument. Be sure to add other cases similar to your case. Have pertinent documents also. We all know what documents are. They're paperwork. As what I said as far as the example. Doctor's reports, school reports, police, CPS, department information. Anything that will help you to develop an argument. A written argument. Safety and well-being of the child or children. It's number 3. Present cases again that are similar in your case which support your case. Any documents which show safety concerns and issues should be introduced. So here it is again. You're searching cases in the annotated code in your state along with other cases. Annotated code of whatever state you're in will tell you, and then you research and you find other cases that have safety issues and concerns as far as children from an opposing side, and you use those cases to put into your argument so that judge can see you've done your homework. Your I's are dotted and your T's are crossed. Period. Number 4, a stability factor. Introduce living arrangements, job, living conditions, groceries and other bills that go along with daily expenses. You've been living here for so long. You've been employed on the same job for so long. And you provide for your household. You are taking care of all the bills, and you have all the bills, statements, and receipts that you use to maintain and run your household. But being in that same house, that same job, are strong critical stability factors in your argument. A child's testimony. If the child or children are old enough, he or she or they should be able to form a rational testimony that is credible to the court and taken into consideration by the master or judge before a conclusion is made. That's very important, because when a child gets to be a certain age, he or she can form a rational decision based upon something. As I said, my book is written to where as though a 10 or 12-year-old child can understand it. My first 2 books are written to where as though a 10 or 12-year-old child can understand it and see what went on in my court case and see what went wrong. So that child can be of age and testify and express him or herself. And it should be taken in consideration by a master and judge. Because after all, we're here, quote unquote, the best interest of the child. The best interest of a child. And judges are so quick to say ignorance is no excuse to the law. Ignorance is no excuse to the law. Chew on your own words, judges. When you can look and see what's best for a child, but you turn the other way. When you can see what's in the best interest of a child or children, but you turn the other way. Don't look the other way, judges, masters around the world. Don't look the other way. When you look the other way, you put a child or children in jeopardy. You keep a child or children in harm's way. You keep a child or children in a hostile environment. That when that child absorbs in his or her immune system and his psychological thinking and reasoning become hostile, you have just caused another hostile human being that will grow up and be hostile based upon your decision, based upon your ink pen, based upon what your attorneys give you. Another human being hostile, angry, upset, mad, discouraged, frustrated, bitter, mean, full of turmoil because you turned your head or because you turned a deaf ear. Listen well to these children. A songwriter said he believed that children are the future. If children are the future, let's treat them like they are the future. Let's make them think and believe that they are the future. Let's have them think and believe that they can do anything and achieve anything that they want to. Let's pull self-esteem up high. Let's have them to develop positive, mental, psychological, and emotional actions. Let's have them think that they are good. But based upon that decision that you as a judge or you as a master make with your ink pen, by turning your head, by turning your ear, when all the proof is in the pudding as to what will serve the best interest of this child or children. Before you use your ink pen, listen to that child or children. The conclusion. Your conclusion should say exactly what you are requesting and seeking in your appeal. It should be straight and direct and to the point, with no room for guessing as to why you are there presenting your case yourself. Your Honor, I'm here for this. This is my conclusion. This is what I'm asking for. Don't leave no room. No guessing games. Don't let it be a thought process. None. At the end of this, you will want to have respectfully submitted with your name, address, phone number, and the fact that you are representing yourself. Pro se. I loved it. Yes, I did. Because I made the attorneys before me look incompetent at their jobs. And although the judges will not admit it, I made some of them look incompetent at their profession also. I had to help 3 of them with paperwork. Was I being smart? No. Sarcasm? No. I knew the law just as well as they did. But I don't have no law degree. I got intelligence. Something they can't take away. And it's all in this book. A father's self-representation. Hosea 4 and 6, eliminating the middleman, the attorney, that family law guy. Get him up out of there. Your pertinent information provision should follow after the above. And this is an example of what is to be in it. 0-000-1 report abuse by someone, expert witnesses. Inside of this, you should have the laws that support your issue. The issue here is child custody. Reporting abuse. Since this didn't go the way that it was planned to go, the state law on abuse should be introduced here. 0-0002 report by same. Report same by others. Anybody else who have any type of records of abuse to a child that you know of should be introduced here. Write that law in there. 0-0003 investigations. Write that law in there too, because somebody should have investigated any type of child abuse, and other people should have been involved. 0-0004 access to medical records. Write that law in there too, because if there's child abuse, physical child abuse there, or any type of child abuse is documented, is investigated, then it's in medical records. It's accessible. All of that is how your brief should look. And it's smooth sailing. When you mention something in your brief, you add the letter E of where it can be found in your record extract. If you have Mrs. Spargus live here, E1, you look over in your extract and find page E1, and that will tell you where she lives. You have another bit of information. Mike Cucumber Jr. was in a football game and he got hurt. E25 at the end of that sentence or that paragraph in your brief. Go to your record extract and look up E25. E meaning extract, 25 is page. And you will find everything that happened to Mike L. Cucumber Jr. on that day as far as this football game is concerned. He got hit real bad, ambulance came, he had a fractured ankle. And the record extract will have the initial case, factual documents, exhibits, and any other pertinent information, documents enclosed. When these two are done well, crossing every T and dotting every I, what judge or attorney would not give you your props in the job that you have done? For it was well done. And the best part about it is, you've done this yourself, with no law degree, none whatsoever. A father's self-representation, Hosea 4 and 6. Eliminate the middleman, the attorney. This is a blueprint. This is the formula for child custody, for fathers, for what's best for the child or children, not for spiteful or vindictive reasons, but for what's best for the child or children. This book is designed, this book was written to put family law attorneys out of business. Family law attorneys, when fathers get this information, this is my law degree right here. What you went to school for in 4 years to learn, I learned it in about an hour, 30 minutes to an hour, and I perfected it, and it's all in this book. It's all in this book. Family law attorneys, watch out. You may be practicing something else. But the reverse side of this is, while you're representing somebody that's throwing lies at a plaintiff, you never know when it'll be your turn. The attorney that represented my son's mother and When a Judge Can't Judge had, I think she was a 3-year-old girl. And I said to him, all these lies that you're going along with, what happens? What happens when the shoe is on the other foot? Another guy who I went to get help from worked for the state of Maryland, trying to get some information from him and some assistance from him. He had this look, macho look, chest all up, all that stuff like that. I said, okay, sir, what happens when it's your turn? Ain't gonna never happen to me, my marriage, my children. About 3 years later, I was a guest speaker at a Father's Day luncheon. That same man who told me that, he was in the audience. That same man who told me that, no wedding band, divorced. That same man, children were not living with him. That same man had visitation rights. That same man was paying child support. That same man, world crumbled. And when he looked at me, he couldn't say nothing. But good work, mister. See, you never know. What goes around, comes around. You reap what you sow, and now it's karma. You can order my book at Barnes & Nobles, Amazon, Borders, Author House. You can go on eBay. You can Google my name, Nelson L. Moody Sr., and get information about my book and my other books. As far as South Africa, India, the UK, some parts of Europe, in the Far East, and throughout the United States. My book is available around the world in 191 countries just by ordering it. When a Judge Can't Judge, My Nightmare of the Court System in Baltimore, Maryland. When a Judge Can't Judge, Part 2, The Conclusion. Men Are Loving, Caring Parents too. And the one we're talking about now, A Father's Self-Representation. Hosea 4 and 6, Eliminating Middleman. I'm on Facebook, Black Planet, Mingle City, MySpace. I can be contacted at nellmoody7 at yahoo.com. You can visit my website, www.nelsonlmoodysr, that's sr.info. You can also visit me on YouTube under International Fathers. One word. Once again, I'm your host and your creator of International Fathers, Nelson L. Moody Sr. Fathers. Call those children. Children. Call those fathers. Fathers, hug and embrace those children. And children, hug and embrace those fathers. I'm also a member of CambridgeWho'sWho.com. Until next time.